Hello everyone, welcome to the General Studies Paper 2 analysis by Baji Rao IAS Academy. Right? So, from the past few lectures, we have been discussing UPSC 2023 mains question papers. Right? So, today also we will discuss the General Studies Paper 2 questions. Since yesterday we have discussed all the questions in General Studies Paper 1, right? So in this session we will discuss General Studies Paper 2 questions that are related to Indian polity and Constitution, right? So before proceeding into the discussion, please subscribe to our YouTube channel and also hit the bell icon so that you will get all updates on classes, right? So the first question which is being asked in the General Studies Paper 2 is a constitutionally guaranteed judicial independence is prerequisite for democracy, right? So in India we have a written constitution, and the written constitution has guaranteed judicial independence in our country. So therefore the judiciary itself will protect democracy and the democratic edifice of our nation. So therefore in this question we need to understand what is judicial independence. We need to write judicial independence in the introduction, and in the body part of the answer we need to write how a constitutionally guaranteed judicial independence will be prerequisite of democracy. And first we have to understand what is constitutionally guaranteed judicial independence, right? Now, in the introduction, what you have to write is the concept of judicial or independent judiciary is actually considered as a fundamental pillar in the democracy, right? So, judicial independent judiciary in any democratic nation is actually considered as a fundamental pillar of democracy because it allows courts and judges to execute their responsibilities, right? So they have a certain responsibilities and constitutionally guaranteed responsibilities and powers. So therefore the independence of the judiciary will ensure that the courts and the judges fulfill their responsibilities without any external influences, right? So external influence means there would not be any interference by the judiciary or the legislature on the functioning of the judiciary. However, the principle also plays a pivotal role in preserving the rule of law. Every country has a rule of law, and this independent judiciary as a principle will ensure rule of law in every country. And apart from that, it also safeguards rights and freedoms of individuals. So if you remember, Indian Constitution Article 13 to Article 32 provided for an exhaustive list of fundamental rights for every citizen. So fundamental rights are available not just for the citizens but also foreigners also can enjoy some of the fundamental rights. For example, Indian Constitution Article 21A or Article 21 are available to foreigners as well, right? So this is a very essential, the overall judicial independence is very essential for preserving essence of the democracy within a nation. So if you look at the western democracies, they considered freedom of press, independent judiciary as an essential features of a democracy, right? Essential features and the fundamental pillars of democracy. So therefore independent judiciary is very important. There are several instances and several cases where the judiciary has come forward to protect rights and civil liberties of citizens. So therefore independent judiciary is very important, right? Now the first part of the question is constitutionally guaranteed judicial independence. How constitution has guaranteed judicial independence, and what are the provisions dealing with this judicial independence we have to look into. First, judges have the security of tenure, right? So when judges don't have the security of tenure, they would be exposed to the whims and fancies of the executive. So they will not be able to deliver their responsibilities without a fear and fervor if they don't have security of tenure. So therefore, Indian constitution has provided for the security of tenure for every judge, right? So if you look at this, judges hold office until the age of 65 years, right? So and this was provided by Indian constitution article 124(2). And if you look at the security of the tenure of the high court judges, this they are in the office for 62 years, and this is guaranteed by article 217 of the Indian constitution, right? So you just have to remember the age for the Supreme Court judge and the High Court judge, and also the constitutional provisions which are dealing with the security of tenure of the judges. Secondly, removal of judges, right? So this is one of the most complicated removal process, I would say, in the entire world, because the Supreme Court and High Court judges can only be removed by the process of impeachment. Right? This process of impeachment is not easy. This is a very complicated and the complex process that since India's independence, no judge, even a Supreme Court judge or the High Court judge, never impeached by this procedure. So you can imagine the difficulty in impeaching a judge or the judge of the Supreme Court or the High Court. So such kind of judicial independence the Constitution of India has provided or the guaranteed, right? For example, there are only two grounds for the impeachment of the judges. So what are those two grounds? One is proven misbehavior and incapacity, and those uh, you know uh, uh, two grounds were given in the article 124(4) of the Indian Constitution. And third, salaries and allowances of the judges are charged upon the consolidated fund of India. So you have to understand the difference between uh, uh, you know salaries and allowances made from the consolidated fund of India and charged upon the consolidated fund of India. So when a particular allowances, a particular expenses are charged upon the consolidated fund of India, it is not subjected to voting in the parliament, right? But when it comes to uh, you know charged expenditure made from the consolidated fund of India, it is subjected to voting. So therefore, this provision also ensures judicial independence, right? So judges enjoy independence as their salaries, allowances, and pensions are charged upon the consolidated fund of India, and it is not subjected to voting, right? So next, power to punish for the contempt of court, right? So in India, Supreme Court and High Court, they are both are court of records, and they have the powers to punish for the contempt of court. In India, Constitution Article 129 has provided for the power to punish for the contempt of the court, right? So Article 129 empowers the Supreme Court to punish contempt, and Article 215 grants every high court the same power for contempt of itself, right? So therefore, if you look at the contempt provisions, there's a civil contempt and the criminal contempt, right? So this is not very important, but just understand the provisions which deal with the contempt of court and types of contempt. There are civil contempt and the criminal contempt. Civil contempt deal with the willful disobedience to the orders of the court. However, when it comes to criminal contempt, it is deliberately, trying to, miss. It is deliberately trying to a falsification of the Supreme Court or the High Court judgments, and separation of the judiciary from the executive. So, Article 50 of the Directive Principles of State Policy guaranteed that state must take measures to separate judiciary from the executive in public services of the state. So, these are some of the constitutionally guaranteed provisions which ensure judicial independence. And next, why a constitutionally guaranteed independent judiciary is prerequisite for democracy? We need to look into this aspect as well. First, It ensures judicial independence. The judicial independence, we already discussed the provisions which are dealing with the judicial independence, and it enhances respect for the rule of law. So in India, rule of law provisions are guided by Article 14 of the Constitution, right? So equality before law and equal opportunities. So after that, citizen participation. So universal adult franchise has been provided. That means irrespective of race, religion, caste, every citizen above 18 years is eligible for vote, right? He or she is eligible for casting their respective votes. And free and fair elections. Now there are several judgments from the Supreme Court which provided for the reforms within the election procedure. For example, when it comes to criminalization of politics, and when it comes to the transparency in electoral funding, etc. So, apart from that, the constitutionalism for any country, in order to sustain democracy and the principles of democratic governance, constitutionalism plays a very important role. Right? So, since independence, 1947, India is able to maintain its democratic credentials is because of constitutionalism, a strong constitution. However, several third world countries have fallen to either authoritarianism or military dictatorship. It also ensures checks and balances. So those checks and balances are also very important, that the other institutions will not cross their constitutionally mandated limits, and it will also uphold the fundamental rights of citizens. Upholding fundamental rights of the citizens, they guaranteed in part 3 of the constitution from article 13 to 32. So this is also very important, right? So after that, these constitutionally guaranteed judicial independence is a prerequisite. We need to we need to look into this in a detailed manner. Right. So, firstly, a constitutionally guaranteed judicial independence will help ensure accountability and good governance in any democracy. Because when there's a judicial independence, it could work without fear or fervor, and this ensures that the government actions are aligned with the constitutional principles. For example, there were instances when the executive and the judiciary trying to cross their limits, overstep their limits. So therefore, in several such instances, whether it is a Golaknath case, Minerva Mills case, and Keshwananda Bharati case, the Supreme Court has intervened and it has ensured accountability and good governance. Secondly, interpretation of the Constitution. We all know that the Supreme Court plays a very important role in interpreting the constitutional provisions, whether it is preamble, whether it is main constitutional provisions, right? So the recent progressive judgments, whether it is triple talaq, or decriminalizing section 397, or allowing a woman into the Shabarimala temple, all derived from the progressive interpretation of the Constitution by the Supreme Court, right? So an independent judiciary is essential to serve the final authority of the constitutional matters and ensuring that Constitution is upheld, the supreme law of the land, right? So Constitution is the supreme law of the land. So there's no other law which can overstep the constitutional provisions. So therefore, Supreme Court ensures that the Constitution is the supreme law of the land. So here it is given one example, that is Keshwananda Bharati case. This is one of the very famous case. So in this Keshwananda Bharati judgment, the Supreme Court has provided for the basic structure doctrine. And the basic structure doctrine, what this basic structure doctrine mandates, certain provisions of the Constitution. I mean, they form the basic structure of the Constitution, and Parliament cannot amend those provisions, or Parliament cannot alter the Constitution in such a way that impacts the basic structure of our constitution. So therefore, this interpretation of the constitution will ensure constitutionalism in a democracy. Right? So after that, upholding rule of law is also another feature which judicial independence ensures. Rule of law means that all actions, including those of the government, they should be bound by the legal principles and the constitution. So when other organs of the government they're bound by the rule of law, it prevents the arbitrary exercise of power. Right? So it prevents the arbitrary exercise of whether it is executive or the legislature. They will not show the majoritarian tendencies that would lead to the authoritarian governance structure where it curbs the civil liberties of the people. So here it is given one example where Nandini Sundar and others versus state of Chhattisgarh. So in this particular case, the Supreme Court has iterated the rule of law in upholding democracy. The Supreme Court held the importance or underlined the importance of rule of law in upholding democracy. So after that, judicial independence will also safeguard individual rights and liberties. So when the judiciary is independent, it would be able to safeguard the rights of the people guaranteed under the Part 3 of the Constitution. So if you look at the People's Union for Civil Liberties case, in this case, the Supreme Court has directed the government to provide aid and assistance relief to the drought victims. And in Vishaka guidelines, the Supreme Court has also given certain guidelines to the government that these guidelines need to follow in order to prevent the sexual harassment of women at workplace. Right? So the impartial and independent judiciary that can ensure that citizens receive equal justice and they are shielded from potential abuse by the government. So if you know that fundamental rights are provided by the constitution against the state, right? So those fundamental rights will be applicable or will be provided to every citizen against the state. The state should not intervene to curb or to prevent the fundamental right. So therefore, Supreme Court is a guarantor of the fundamental rights to every citizen. So here it is given the case of K.S. Puttaswamy judgment. This is also one of the most important judgment where Supreme Court has declared right to privacy as part of Article 21. Right to privacy is part of the Article 21. So if you look at Article 21, it has been widening over a period of time. And in 15-mark question in the same paper, UPSC has also asked about the Article 21 and its ever widening nature with changing society. So therefore, Article 21 is very important. So after that, it will also ensure checks and balances. Right? So checks and balances in the sense that, for example, whenever a particular institution and the institution has some constitutionally guaranteed roles and responsibilities, it is overstepping those rules, then the Supreme Court would intervene. Right? So through the power of judicial review, the Supreme Court would intervene. So the power of judicial review has been accorded to the Supreme Court and the High Court by Article 13 of the Indian Constitution. So if any legislation, if any executive decision, if it violates the fundamental rights under Article 13, the Supreme Court can declare that particular enactment as null and void or unconstitutional. So finally, you can conclude the answer by writing about the independence judiciary and its importance in any democracy. Right? So it is a fundamental pillar of Indian Constitution, and that was rightly affirmed by the Supreme Court in S.P. Gupta versus Union of India case. So in this particular case, the Supreme Court has rightly emphasized on the principle of independence of the judiciary. Right? And Supreme Court held that it is an integral part of the overall constitutional framework, and it also forms the bedrock of Indian democratic system. See, at the conclusion, you should use such a words which are, optimistic, positive, and progressive in nature. So therefore, it creates a good impression in the mind of examiner, okay, evaluator. So you will get good marks. So the next question UPSC has asked is, who are entitled to receive free legal aid? And we need to assess the role of National Legal Services Authorities Act. Right. So this question is based on Article 39A of the Constitution. So if you remember Article 39A of the Indian Constitution, it has provided access to justice. It has provided access to justice and free legal aid for all. Free legal, not for all, but those people who are weaker sections and marginalized. So after Article 39, NALSA was established, National Legal Services Authorities Act. So this NALSA was established through a parliamentary legislation in the year 1987. So in the backdrop of National Legal Services Authorities, there was a question. The question is that who are entitled to receive free legal aid? And second part of the question is assess the overall role of the National Legal Services Authorities Act in rendering free legal aid in India. So this question has two parts. Now, firstly, you have to write about Article 39 of the Indian Constitution, because the question is itself based on Article 39A, that is about access to justice and free legal aid for all. So, the Article 39 of the Constitution provides for free legal aid for all. So, this particular article also envisages a legal system that ensures justice. Okay? So it ensures justice irrespective of economic or social disparities among the people. However, still we have a sizable chunk of marginalized and weaker sections and vulnerable sections. So therefore, it is very essential to provide access to justice and free legal aid to those vulnerable categories of population. So in order to uphold this value of providing free legal aid and access to justice that was envisioned by Article 39A, the National Legal Services Authorities Act 1987 was passed by the legislature, and this Legal Services Authorities Act led to the establishment of National Legal Services Authorities, State Legal Services Authorities, and District Legal Services Authorities in a decentralized form. In at different levels. Now, so the eligibility for entitlement of free legal aid. So this is the first part of the question. And who are eligible to receive the free legal aid as part of the as part of the Legal Services Authorities Act 1987. So here a number of sections, they are vulnerable for the free legal aid, entitlement of free legal aid. So they include the members of scheduled caste and scheduled tribe population. In India, both a scheduled caste and scheduled tribe population constitutes around 20% of total population. So therefore, they are socially excluded sections, most of them socially excluded and economically backward sections. So still they are facing historical injustice and they lack access to justice. So therefore, the National Legal Services Authorities will provide a free legal aid to members of scheduled caste and scheduled tribes as well. Secondly, victims of human trafficking and beggar. So this is beggar means bonded labor, bonded laborers. So therefore, this Legal Services Authorities Act 1987 will also provide free legal aid to victims of trafficking and beggar, bonded laborers. So women and child are also considered as a vulnerable categories, and free legal aid will also be extended. mentally ill, otherwise disabled individuals will also be eligible for this aid. And fifth, a person in custody, including custody in a protective home, and a juvenile in juvenile home. Juvenile is a child who is less than 18 years of age, right? So juvenile in a juvenile home, an individual who has an annual income of less than or the amount prescribed by the respective governments. Okay, so they are economically weaker sections. See, if you remember, in prelims 2020 question paper, prelims 2020 question paper, the same question has been asked by the UPSC in that particular question paper, that who among the following are eligible to receive a free legal aid. So therefore, UPSC again asked in the 2023 mains question, uh, so again the same question. So therefore, it is very important that you should analyze the previous year's questions, both prelims and mains questions, whether it is previous years or the current year. So therefore, you have to listen to these analysis. So when you are listening these analysis, you would understand what is the trend of UPSC and how we can structure and answer these questions. So the second part of the question is role of national legal services authorities in rendering free legal aid in India. What effective role they play? So firstly, for prisoners and under trials, legal aid counsels is provided in most of the courts. So in across we have an integrated judiciary. Everyone knows about that. So in our judiciary, legal aid councils were established. Legal aid councils were established, and they provide immediate legal assistance to vulnerable sections. For example, for legal awareness among prisoners, Hak Hamara Bhi To Hai. This was a campaign for providing or the ensuring enhancing the legal awareness among the poor prisoners. That was recently launched by National Legal Services Authority. Secondly, gender justice. So gender justice is also a very important. Women considered very often considered as a vulnerable, category, and they often suffer with problems like domestic violence, dowry, harassment, and harassment of women at workplace and public spaces. Therefore, gender justice and gender equality are also very important, and they can be ensured through free legal aid provided by the NALSA, and assistance would be provided to women in cases of domestic violence. During lockdown, the assistance was extended by NALSA, and NALSA has also launched a national legal aid helpline. So the helpline number is 15100. So legal services for transgender rights. If you look at the NALSA judgment in 2014, where the Supreme Court has asked the government to recognize the transgender people as third gender, so male, female, and transgender. So that judgment is called as a NALSA judgment. And for senior citizens also, NALSA provides free legal aid. If you look at the annual report of National Legal Services Authorities Act, nearly 1 lakh 4,084 senior citizens were assisted through legal services in 2020. And after that, accessibility of legal aid. So amicable dispute resolution through Lok Adalats, Disha, and so if you look at the Disha is designing innovative solutions for holistic access to justice. So apart from the above mentioned programs, NALSA, National Legal Services Authorities Act, has also been constituting Lok Adalats at different levels, and it has also constituted Disha. So E-Lok Adalats will ensure, electronic hearing of cases. And apart from that, legal services mobile apps and legal aid clinics. Now, after that, the legal awareness will also be provided by the National Legal Services Authorities Act. because it is very often conduct legal literacy programs and legal literacy clubs, and uh, this involves paralegal volunteers at different levels. Okay, now you have written first two parts. However, it would be better if you write some of the challenges which currently National Legal Services Authorities has been facing in providing free legal aid for the people. So you can just mention one or two points and then you can conclude on a positive note. So firstly, you can mention about lack of accessibility to the alternate dispute resolution. So what is alternate dispute resolution? So alternate dispute resolution is arbitration, okay, arbitration, negotiation, negotiation, etc. So where you will not directly approach the courts, the law courts, rather than uh, through the alternate dispute resolution, you would settle the disputes in an amicable and mutually beneficial manner. However, still there is a low acceptability in our society for the alternate dispute resolution, because it was highlighted by the former Chief Justice of India that Legal Services Authority handle just 1% of the total litigation. So therefore, there is a need to enhance awareness about the alternate dispute resolution and its importance. Secondly, people have low levels of awareness about the free legal aid which is being provided by the NALSA, because majority of poor and illiterate people, so they are even unaware about the constitutional rights and their legal rights, and they do not very often approach the legal aid forums. And third, inadequate powers to Lok Adalats. Lok Adalats still have inadequate powers. For example, when it comes to penalizing parties for non-compliance of the decisions taken by the Lok Adalats, and they still have a very limited powers compared to the civil courts. So all these factors have been limiting the functioning or the effectiveness of Lok Adalats. After that, the underutilization of the paralegal volunteers. So in the previous slide, we have discussed that national legal services authorities have been promoting awareness at different levels, particularly at local levels through paralegal volunteers. However, still we are underutilizing those para volunteers because there's lack of proper training and capacity building and monitoring and accountability measures. So since the monitoring and accountability measures, training and capacity building is lacking, we are still underutilizing these para legal volunteers. And support from advocates and lawyers is also lacking because there's lack of interest in pro bono cases. Pro bono cases are cases which involve a significant social interest. So therefore, there's a still lack of support from advocates and lawyers. So therefore, there's a need for greater sensitization of lawyers and advocates, lawyers and advocates. So you mentioned all the parts of the question. Now you have to conclude this answer by emphasizing on further strengthening the alternate dispute resolution through awareness, and that will ensure fulfilling the objectives which are provided under Article 39A of the Constitution. So Article 39A of the Constitution that provides for uh, equal justice and free legal aid for the all. So this is how you need to conclude this answer. The third question, which is given in this which is given in general studies paper 2, is about 74th constitutional amendment. 74th constitutional amendment. So we all know that about the 73rd constitutional amendment and 74th constitutional amendment. So the 73rd constitutional amendment envisions village self governance, and 74th constitutional amendment act envisions urban local governance. Okay, this is about urban local governance. Even though the constitutional status has been accorded to the local governance, the state governments, which are still reluctant to empower the urban local bodies. So they are still reluctant to in providing powers to the urban local bodies, both functionally and financially. So we need to write why state governments are still reluctant to provide functions and powers to urban local bodies, and what steps and what measures we need to take so that states could provide significant amount of functions and finances to the urban local bodies. So you can introduce this answer by writing about the 74th Constitutional Amendment Act. Now the basic objective of 73rd and 74th Constitutional Amendment Act is democratic decentralization. So democratic decentralization is the basic objective of the 73rd and 74th Constitutional Amendment Act. So they were enacted in 1992. And what happens ki through democratic decentralization, that empowers local bodies, and not just local bodies, it will also increase the participation of the people. It will also increase the participation of people. So it provided a constitutional status to urban local bodies. However, even though there's a constitutional status to urban local bodies, they still face challenges with respect to funds, functions, and functionaries, and even functionality. So you can call it 4F, but most popularly it is known as 3F. So it is generally advisable that in conclusion you just mention about the need for providing funds, functions, and functionaries to both urban local bodies and rural self-governance institutions. The first part we need to write why state governments are reluctant to provide or to empower the local bodies. So why they are reluctant? So firstly, so their own source of revenues will get impacted because urban local bodies are largely dependent on grants from the states, and even though they're dependent on grants from the state, they lack a diversified sources of revenue because 60% of the revenue from the property tax alone. So they have not diversified their revenue base. So the urban local bodies. So if you look at some data of the revenue, their own revenue of urban local bodies, it has been constantly declining. For example, in 2001, 60% of total revenue of the urban local bodies, total revenue of the urban local bodies come from their own sources, their own revenue sources. However, in the year 2021, it has become around 42%. It has become 42%. So therefore, you can see a declining trend in the own revenue sources of urban local bodies. And secondly, there is an irregularity in the formation of State Finance Commission. So uh, 243, Article 243I has mandated constitution of the State Finance Commission. However, several state governments have not been regularly, forming the state finance commissions. There were still recommendations that uh, the devolution of finances to local bodies. In fact, the Finance Commission itself has recommended that the devolution of finances to state governments or to the local bodies should be dependent on state governments regularly constituting state finance commission, and also an effective functioning of the state election commission, which regularly constitute elections. The third point is appointment of mayors. Now, in every urban local body, there is a position called mayor, right? So the position of mayor is indirectly elected by the elected members of the urban local bodies. However, even though the mayor is being elected, he or she significantly lack powers. So majority of the powers are concentrated in commissioners, the municipal commissioners appointed by the respective state governments. So therefore, there is a need to give more and more powers to mayors. In fact, many states like MP and UP, they have directly elected mayors. So even though they have directly elected mayors, but they are just a nominal heads, like what governor is and what president is. So they are just a nominal heads, and due to inadequate power devolution. In fact, adequate amount of powers are being given to the municipal commissioner by the state government. So therefore, the next point would be devolution of powers. So as per the devolution index, the devolution index is actually measures the devolution of powers. So the devolution index says devolution of functions and powers stands merely at 10% in various states, right? So out of 100 percentage, only 10% of powers being devolved to the local governance institutions. Now, apart from that, there is still a functional overlap. Now, not just a functional overlap, but several parallel bodies are being created, right? For example, for implementation of the smart cities program, so there was, special purpose vehicle. So, special purpose vehicle is created with significant powers. Now, parallel body has created. So, therefore, the dilution of existing functions and the powers of the urban local bodies. Now, how functional overlapping has been taking place? The 74th Constitutional Amendment Act 1992 has actually empowered the state governments, and in fact, it has provided 18 subjects to urban local bodies, and these functions are often carried out by the parallel bodies or parastatal institutions. Now, if you look at the example for this parallel bodies or the parastatal institutions, the Bengaluru Development Authority for land regulation and Karnataka Slum Clearance Board for slum rehabilitation. So these are some of the parastatal bodies or parallel institutions. And after that, there's an establishment of ward committees as well. So many states do not constitute ward committees. So ward committees is in fact mandated by the constitution itself under article 74 sorry 74th Constitutional Amendment Act, article 243. It is mandated to constitute ward committees. However, many states have not constituted ward committees. So, a non-transparent procedure for appointment, delay in elections is also a major cause. So, in fact, Second Administrative Reforms Commission. In fact, you look at Second Administrative Reforms Commission. So, this commission has mandated. The Second Administrative Reforms Commission has mandated that there should be ward committees. Okay, so there should be ward committees. They should be ward committees. So a non-transparent procedure for appointment or delay in elections. Right? So after that, the lack of involvement in decision making. So for example, municipal commissioner vis-a-vis mayor. So lack of involvement in decision making. So, however, some states are providing adequate powers and resources to local bodies for maintaining harmonious coordination with them. So, firstly, capacity building. Right? So, capacity building, like states like Karnataka and Mizoram, they are focusing on capacity building of local bodies. So, for improving their functioning, and they are also providing them assistance in localization of sustainable development goals. And secondly, financial autonomy is being provided. For example, there are states like Gujarat, Maharashtra, and Andhra Pradesh. So they still have provided significant amount of financial autonomy for the urban local bodies. So for generating their own sources of revenue also. And thirdly, the political representation is also being provided to women. Nearly 21 states in India have more than 50% reservation for women in local bodies. And third, fourth, devolution of resources. So under initiatives like Smart Cities Mission, Amrut Mission, so the states have been devolving significant amount of powers to these urban local bodies, right? Now, when you conclude this answer, you should emphasize on the need of giving more powers. For example, you can quote the Second Administrative Reforms Commission recommendations over urban local bodies. And you can also write about the Judge Ahluwalia Committee. Judge Ahluwalia Committee. So what this committee has recommended? Judge Ahluwalia Committee has recommended that there should be more powers and functions and finances to the state by the to the respective urban local bodies, so that it further augment the economic growth. So because urban local bodies are growth engines, so since they are growth engines, there is a need to provide more powers and functions, and that fulfill the the goal of greater democratic decentralization at the local level. So this is how you need to conclude this answer in a more positive and optimistic manner. Fourth, compare and contrast the British and Indian approaches to parliamentary sovereignty. Now, so see, every year UPSC asks at least one question in General Studies paper 1. In General Studies paper 1. So at least one question. So sorry, in General Studies paper 2, at least one question uh, of comparison of different political systems, whether it is India, US, the presidential form, and British and Indian parliamentary comparison, etc. So this year the question has been asked to compare and contrast British and Indian approaches to parliamentary sovereignty, right? So right. Now, in the introduction, you just have to write about the parliamentary sovereignty. What does parliamentary sovereignty means? So, the parliamentary sovereignty means an absolute and supreme authority of country's legislative body, right? So, how the country's supreme legislative body have the absolute and supreme authority, and the absolute authority to make legislation, amend the constitution, or the repeal existing laws without any interference or constraint from other organs or the state. So this is, in fact, Article 3, 368 of the Indian Constitution has provided for the amendment of the constitution. The parliament can amend the constitution, any part of the constitution, but subjected to basic structure doctrine, and that is given by the Keshwanand Bharati judgment. So firstly, election once in 5 years. So election usually takes place once in 5 years in British Parliament, for British Parliament, because we are now uh, contrasting Indian Parliament with British Parliament, and this particular image consists of both comparison and contrast. As like British Parliament in India, also election takes place once in every 5 years. And secondly, one can contest only twice. For example, an MP is contesting from one particular constituency, and he can constitute only for 2 terms, not multiple times. However, in India, any number of times a member can constitute elections. So this is one major difference between Indian and British Parliament. And third, no criminal case should be pending against any particular member in the parliament. However, there's an exception in India. There's a problem. There's no problem with trial and conviction, even pending number of cases below 3 years. So, because of this reason, there's an increasing criminalization of politics. Criminalization of politics as a trend has been developing in Indian polity. And fourth, they must compulsorily reside in elected constituencies. So if a particular MP is elected from a particular constituency, he must compulsorily reside in elected constituency. However, it is not mandatory or necessary in the Indian Parliament. And fifth, attendance to Parliament must be above 90%. So attendance must be above 90% out of 230 working days. And fifth one is, it is not fixed number to attend parliament, and no penalty too has been given. And sixth, grievances are attended by fixed 30 days with token system. So if there are any grievances, so they are attended by within 13 days with a token system. However, in Indian Parliament, there is no fixed deadline, and complainant left at the mercy of MP's office staff and officials. For example, a citizen from a particular constituency reaches MP with a grievance, and there's no guarantee that the grievance would be redressed, and there's no such timeline. So here, the British form of the government is more accountable. The MPs are more accountable for the voters and the citizens, unlike the Indian system, where MPs were not accountable in the formal sense to the voters and the citizens. And seventh, details of expenditure spent on civic work is displayed every week. So civic works will be taken place, and expenditure of the civic works will also be displayed every week. On the other hand, there is no accountability. There is no accountability or on the part of the parliamentarians, and details will never be disclosed in details. And no government vehicle for personal use or foreign visit. But when it comes to Indian system of parliament, government sponsors foreign tour and vehicles for family and staff as well. So this is the wastage of public money for the private needs of MPs. And ninth, they must pay income tax on salaries. So Indian MPs are exempted from income tax. So you can see how the difference between democracy in Britain and India. Even so, they have a huge privileges in India. So because of these reasons, there is a decline in Indian Parliament. Whether it is uh, bills referring to the parliamentary committees, whether it is the quality of discussions and debates taken place in Indian Parliament, and that there is an increasing trend of criminalization of politics, and even parliamentarians have been preferring their personal interest over the larger public interest or the national interest. So there is a need for significant electoral reforms. And there is also need for significantly improving the quality of parliamentary debates. Okay, and so there is a need for public debate on the parliamentary reforms as well. Now, after that, there are some similarities between Indian and British approaches to the parliamentary sovereignty. So, what are those similarities? So, the similarities include a supreme legislative body. Supreme legislative body means the legislature, the parliament has the supreme powers to amend the constitution, but in India it is subjected to the basic structure doctrine. However, in Britain it is not subjected to basic structure, but it is a supreme legislative body. So you can give the examples of a Brexit, that legislation passed by UK, and GST bill in India. And secondly, accountability of the executive. So in both the parliaments, executive is largely accountable to the legislature, right? So they are collectively responsible to the Lok Sabha in Indian constitution. So financial control. So both parliaments oversee national budgets and economic policies. In India, the union budget is presented annually in the Lok Sabha. Similarly, in UK also, the Chancellor of Exchequer presents budget in the House of Commons. And the third aspect would be both systems have recognized the separation of the principle of separation of powers. So where judiciary is independent of the legislature and executive also. So this is guaranteed by Article 50 of the Indian Constitution and Article 112 and 211 of the Indian Constitution. Now, committee system. So committees usually play a crucial role in detailed analysis of various issues. For example, in India, we have a public accounts committee, and this public accounts committee is similar for both UK and India, and they usually oversee government expenditure to ensure they are lawful and efficient, right? So this is how you need to write the comparison and contrast between Indian Parliament and the British Parliament. So in the conclusion, you just have to mention about the significance of the parliamentary system, the parliamentary form of government as a representative model of governance for further strengthening the democracy. And you can also stress here the need for improving the parliamentary debate quality, and the need for parliament working in the in the larger national interest and the public interest. So this way you can conclude this answer, right? So these are the questions for general studies paper 2, and in the next session we will discuss the remaining questions. Okay, so thank you so much.